All right, good afternoon, everyone. My name is Ari Rothman. I am a partner at the firm. I'm in our LA office right now, as you can see behind me, and I'm joined by my partner and colleagues, Shahin Rothermel and Jasmine Martinez. They are in our DC office, so we have you literally covered today, coast to coast, around the world, really, because because we're talking about email marketing. If you send email marketing into California, for example, it doesn't matter where you send it from. You are going to be subject to that statute. So we're excited to bring this presentation to you today. It's a really developing area, and thank you all for joining us. So we'll go on to first talk about, or at least identify, the applicable federal law here, and it's the Federal Can-Spam Act. And the overview on that is that Congress enacted that statute in 2003 to establish uniform standards for email marketing. So the idea was Congress wanted to regulate the field, with one exception, which we'll get to in a minute. The idea was that states were trying to figure out how to regulate email marketing in each of their states, and it was confusing and inconsistent. And so CAN-SPAM is designed to provide one uniform set of rules. What it really targets is materially false and deceptive emails in their headers. So that'll be the from names, where the email's coming from, subject lines, and misleading content about the message purpose. Here's the big thing about CAN-SPAM. There is a preemption clause in it that says that CAN-SPAM preempts all state laws governing commercial email, except to the extent that those statutes prohibit material falsity or deception in them. And we'll get into that in a minute, but that's really important because, for example, there are statutes out there like California Business and Professions Code 17529.2 that on its face says it's unlawful to send out unsolicited commercial email, period. Doesn't say anything about falsity, doesn't say anything about deception. If you're just looking at that statute, you would think that it was unlawful to send out unsolicited emails under California law to California residents or from California. And CAN-SPAM says, no, you can't, we're not going to let states prohibit that. In kind of sharp terms, it's the CAN-SPAM Act, not the CAN-SPAM Act. So we'll get more into that preemption, but that's a key part because you would never know that if you're reading a state law without reference to the federal law. So that leads to our first fact or myth, and this is what we're going to try and do throughout the presentation, is debunk some myths and maybe reinforce some facts. Companies must have affirmative opt-in consent to send marketing emails. You've got to have someone's permission to send marketing emails. Is that a fact or is that a myth? That is, under CAN-SPAM and because of the preemption clause, a myth. It regulates commercial emails and allows direct marketing email messages to be sent to anyone without permission until they opt out. And you have to have opt-out mechanisms in there. So if someone's opted out, they're on your suppression list, you can't email them, but you can send out as much commercial email as you want. The fact that it's unsolicited is irrelevant unless they've opted out. It does not ban unsolicited commercial emails.
So let's talk about a little bit of the requirements of CAN-SPAM. As Ari mentioned, I'm Shahin Rothman, I'm a partner in our ad law group, and we defend a lot of these cases involving CAN-SPAM and state anti-spam law statute lawsuits. So one of the first questions that we get in terms of CAN-SPAM compliance is what are the requirements and what kind of emails do they apply to? And the first question that we'll always ask is whether or not the email is commercial or transactional. That question is the threshold question that really defines what the requirements are for that email. We're looking at a commercial email. The primary purpose of that email is one that promotes a commercial product or service or website. In other words, it's something that's really promoting something that's going to end up in a sale. A transactional email, by contrast, is one, or relationship email is one, where the primary purpose is one that facilitates or addresses a transaction or relationship that has already occurred. So we're thinking about things like If you have an automatic renewal program or a receipt, like that's the receipt email. If you have any type of change to the terms of services, that's going to be there. Any type of warranty, recall, safety, or security information, that's going to be there too. If somebody's ordered something that is a digital product, then they're purchasing that, then the delivery of the email that is something that they purchased is going to be a transactional or relationship email because they've already bought it, right? So what are the requirements for commercial emails? Because that's really where CAN-SPAM goes at. CAN-SPAM says that in terms of header information, you can't have any false or misleading header information. We'll talk about what header information means in a little bit. Subject line. You cannot have a deceptive subject line that deceives people about the content or the subject matter of the email. You have to clearly indicate that the email is commercial. Identify it as an advertisement. Having said that, the Federal Trade Commission has made clear that the word or the labeling requirement, advertisement or ADV, is not required. It just has to be really clear to somebody who's reading the email that it is a commercial email, that it's something that's advertising, right? It doesn't have to actually use the word advertisement. It must include an opt-out message, an unsubscribe mechanism, and that must be clearly and conspicuously labeled so somebody understands I can click on this button and I can unsubscribe from future emails from this sender, from this advertiser. And that opt-out mechanism must remain operational for at least 30 days. And that opt-out request has to be honored in at least 10 business days. Although, as with every opt-out, we recommend an email or telemarketing for that matter. We recommend doing it as soon as possible. Really honor that as soon as possible. Include the contact details. CAN-SPAM says that you have to include the sender's valid physical postal address. That can be a PO box as long as it's appropriately registered and you have 2 forms of ID as required. And if somebody does opt out, then subsequent commercial emails can be sent only if the recipient gives their affirmative consent to receive those future commercial emails. So as I mentioned previously, CAN-SPAM prohibits certain header information practices. Using false or misleading header information. A lot of plaintiffs say that means unregistered domain names, that your domain names need to be publicly or registered, that they are not permitted to be false or proxy registered. We'll talk about whether or not that's true and how courts have addressed that argument. Using misleading sender names or false identities or third parties' identities when it's really, really clear. Ari's going to send an email, but it says it comes from bank of so-and-so. That's going to be false or misleading. Or using the names of a person or entity that's unavailable to respond to the email. With respect to subject lines, any type of deceptive subject line that suggests something different than what's in the body of the email. Let's say, for example, you get an email that says, here's your subscription information for your new subscription. Thanks for signing up. Then you open the email and it's an email suggesting that, oh, here you can buy some shoes on sale. That subject line doesn't correspond with the body of the email. And so CAN-SPAM says that you're not allowed to mislead reasonable recipients about a material fact about the email's contents or subject matter. One thing we're seeing a lot of is this idea of implying a prior relationship where none exists. The idea of, oh, hey, you bought something, or hey, you asked for something. You open the email and it's actually somebody who you've never interacted with in your life. So those are some of the CAN-SPAM challenges that we're seeing over time.
Yeah, and I think it's really important to note that on this slide, these are really some of these are like theories that the plaintiff's lawyers are advancing as opposed
Absolutely.
to actual prohibitions. Like you can have like proxy registered domain names. That's a big fight that is in the court system and has been in the court system. Something unlawful about that per se. So when we're talking about prohibited email practices, we're really talking about what is being challenged right now, not necessarily what is actually the case of the law.
Absolutely right. And courts are coming out in different ways on all of this. We talked about header information. Jasmine, do you want to talk about what header information means?
Yeah, so what exactly are courts looking at when they're considering header information? Well, when an email sent, the header contains essential routing details. And this information helps identify where the message came from, where it's going, and how it's being delivered. There are three key components in the header. First, they're looking at the originating domain name, which identifies the domain that sent the email. And as Shahin mentioned earlier, this is where they're considering whether it was registered, whether it was not registered, whether it was proxy registered. And so there's a lot of considerations. Second, the originating email address or the from name, and that will include it's the specific sender's email address. So it identifies who the sender is. And then any other information that can identify the person or entity initiating the message. So we did a little test email here where Shahin messaged me. And if you look here, it was very simple to locate. We right-clicked, and I think it's a find header information. And then it populated this information where it shows it came from Shahin, the from name. And then the subject line obviously is there as well. That's not included in the header information, although there is some case law that does consider that. But all of it's there, the message ID, the routing information. And so you're able to identify where the email's coming from and who.
Yeah, absolutely. And so if you look at it's really the from and the to line, I would say. And when you're looking at the domain name, you're looking at whatever's after the at, and then the from name, it's amorphous, right? It could be the full email address, like so.rothermel@venable.com. It could be the friendly from name, it's just Rothermel Shahin O. So it's anything that identifies the source, destination, routing details of the email. So agree completely there. So we get this question a lot. Does canned spam provide a private right of action? Yes, it does. So it's generally enforced by the Federal Trade Commission and state attorneys general. As of 2025, you could have $53,000 or more in $88 in statutory violations per email. There's also a limited private right of action for internet access services. It's not for a John Doe consumer recipient like you and me. So Xmission, Zuba, other entities that operate internet access services. Think of anybody who operates a service that lets people use their email server. I sign up for an email address with this person, and something goes sideways with canned spam, then that entity can then sue under canned spam. And in an action by an IAS, you get up to $100 per violation, or for certain violations, or up to $25 in other violations, and damages can be trebled. And a lot of people say, well, oh no, there's really no private right of action. But what Ori can tell you, definitely from experience, and I can tell you as well, is that yes, these IASs will file lawsuits, and they will really go after you, because if you do violate canned spam, then their argument is that it interacts with their canned spam filters and their general ability to provide email services to consumers. All right, is this a fact or a myth?
Canned spam preempts all state email marketing laws. Sort of covered that a minute ago. That is a myth. It preempts state laws except for material falsity or deception. And that is a fight that the defense side, I've only been on the defense side, and the plaintiff side have been fighting for most of my career. When these laws went into effect, what is material falsity and deception? One of the leading cases that sort of started the definitions around what is materially false or deceptive came out of a Fourth Circuit case called Omega World Travel versus Mama Graphics in 2006. And the question there was, did the nature of the emails, were they materially false and misleading, or did they contain inaccuracies that might have been literally false that didn't matter? Were they immaterial, in which case they would not be constitute material falsity or deception? And the Fourth Circuit there found that the claims were preempted because even though the sending domain was not linked to the defendants, there were other ways to find who was involved in that email. You opened it up, there was no question about who the advertiser was or what it was advertising. There was an opt-out method, there was a mailing address, there was a phone number. Court wasn't saying that those things are required for preemption, but what the court was saying was, look, anybody who got one of these emails, even if there might have been technical inaccuracies in them, there's no question who was being advertised in the emails. And the case law since then has developed with, I mean, I don't know if inconsistent results. I think some courts, especially in California, have taken an overly cautious view of what's preempted versus not preempted. I think eventually, and I can't give you a timeline on this, I think with enough, if these spam cases keep on getting filed, I think even California is going to realize and say, look, like if you're getting a bunch of emails and there's no question who's advertising in them, we don't care about anything else. But we're not there yet because there are some courts that are, looking at this more surgically. What's our next one here? And that takes us to California's anti-spam law. The reason why we're spending a lot of time on California is because, well, first of all, as a state, it has the largest percentage population in the US. But two, it has arguably the strictest or one of the more strict set of rules, and it's by far and away the most often litigated. I think I've definitely had more California state spam cases by multiples, even if you add up all the other states that have them. And a lot of people look to the California case law when they're looking at other decisions as well, or other states as well. So we're focusing on this one. Does this one have a private right of action or not? Fact or myth? Based on what I just said, it's a fact. Absolutely. Unlike can spam, a recipient of an email can sue under the California statute. So you've got the government that can sue under it, you've got ISPs that can sue under it, and you've got recipients in California. The addressee of the email, if you're in California, you can sue under this statute. And although we're actually don't necessarily agree with this from a plain statutory construction standpoint, but courts have allowed companies to be liable for actions of their independent contractors and third-party email vendors in certain circumstances. We don't think that the statutory language supports that, but that is where some of the decisions have gone so far. Jasmine, would you want to maybe talk about some enforcement issues there too? Or I guess that was yours. You do the next one.
Okay. We're talking about the prohibited email practices in health. So I know you guys are working on a lot of these cases right now, which is interesting, right? Because there's a lot that's been filed. A lot of people think that there's no private right of action, but a lot of these cases actually have been filed, and we're getting a lot of these demands as well. So Jasmine, do you want to talk about the prohibited practices?
Yes. So under the statute, you are not allowed to use third-party domain names without their permission. And there's not a lot of case law on this specific provision, but there are some. But we mostly see cases coming from the next two provisions that prohibit falsified, misrepresented, or forged header information. Again, that's including the domain names and the from names, any identifying information about the sender. And then it also prohibits misleading subject lines that do not reflect the true content of the commercial email. So there's some case law we'll discuss later on in the presentation that takes into consideration the body of the email.
Yeah, the subject lines is actually a really interesting one that I'm excited to talk about. We talked about can spam saying that the subject line must correspond with the body of the email, and it can't misrepresent the subject or the subject matter of the email or the content of the email. But we'll talk about that because California it really tracks can spam on that requirement, but we'll talk about some other states that don't necessarily and how private plaintiffs are using that. Because when we're looking at all of this, we talked about can spam. It has a very narrow private right of action. It's only for internet access services, so only those companies that provide access to emails. But California, as Ari mentioned, is much, much broader. And then a lot of the other states that we'll talk about with the cases are much, much broader as well. So you're looking at exposure that's beyond just 4 or 5 potential or 10 potential plaintiffs. You're looking at really innumerous plaintiffs that could sue you under those statutes.
So then the header information requirements, the statute doesn't say what must be in a header. So we've sort of developed what we think the requirements could be according to the challenges that we're seeing. Obviously, if an email header is truthful and non-misleading, it's not going to violate the statute. And if it accurately conveys the source where the email came from with the accurate original domain name and a from name and a from line, that too, in our view, would not that would comply with the statute and not lead to this materially false or misleading violation, which is what a plaintiff will need to show to trigger violation of the statute. Now, what makes a header materially false or misleading then? Well, if you, and this is sort of, it's change or obscure the sender's identification, lying about the sender. If the sender is someone other than what was put into the email, that could be materially false and misleading. Although we've taken the position that if there is other information, just like the Omega case, that enables the recipient to identify who is involved in the email, whether through a phone number, postal address, or even a website, who is in the from a name or what is in the header may not matter. I mean, I actually take the position and believe that sometimes the sender information is just completely irrelevant. If it's a commercial email that's advertising a good or service and everybody knows who is advertised in the email, who the sender is irrelevant. Haven't gotten necessarily a court to agree with me on that one yet, but hopefully sometime soon that will happen. If there's active concealment that would not enable someone to handle the email, that could be a violation. But again, there's a decision called Clefman versus Vonage that's a California decision that suggests that maybe that might not be enough either. Or changes that hinder the recipient from contacting the sender. Really, another way of saying it is don't lie in the emails. I mean, if there's something that's just false that would, lead someone to contact someone other than who's involved in the email, that's going to be a problem. Sort of like a bait and switch is another way to look at it. And there's really no reason to do that unless unless you want to obscure that information for nefarious purposes. We see that very rarely where it's an active campaign to do that. Shahin, what about the from name requirements?
Yeah, so what's the question here? The question is, does a from name need to actually say the official legal name of the entity that is sending the email? And the answer generally is no, with some restrictions. You can use a DBA as long as the DBA is properly registered and accurately identifies the sender, person, company, or brand. That goes back to what Ari said, right? Is that in the from line, somebody needs to see the name and say, okay, it either like tells me who it's coming from and I can figure it out from there, or it's something that once I read the email, I'm going to be able to figure it out. So when we're looking at from lines, we're looking at things like the legal company name, the brand name, and it needs to be like a well-known brand name. It can't be something like, well, I'm Shahin and I now started this brand called, some random name with a bunch of letters in it. A trade name, a business division name. So we see this quite often, a company that operates through multiple business divisions, and it doesn't want to send the email from its corporate umbrella name. It wants to actually send the email from the business division that is related to in the email. And so that's another acceptable identifier based on the current case law. But at the end of the day, the best practice is that the from name matches the sending or advertising entity. And we look at this sort of like a mirror rule. The name and the from name matches whatever's being advertised in the email. Somebody clicks on that advertisement, they go to a web page that matches the from name. In other words, your experience is consistent throughout. You get an email from somebody, you open the email, it's from the same person, you click on the button, you get to a website, it's from the same person. And in the email, when you look at the identifying contact information, it's got the same from information. So really thinking about it as having a consistent consumer experience. And back to Ari's point, you're not lying, you're not obfuscating who it's from. Now, one thing that I will say is that this is a general rule. We are seeing so many technical challenges to all of this, including even registered DBAs. They say it doesn't matter if it's a registered DBA, you got to go all the way up to the corporate umbrella, and that's who needs to be in the from name. And therefore, even if the brand name or the from line is registered, you still have some risks if it's too generic. So looking at this on a case-by-case basis is somewhat important to determine your risk, looking at the overall experience of the customer or the recipient.
So how do these from name cases play out in California? We have here Guthrie Ranker. The emails at issue were advertisements for Guthrie's various consumer brands, but they did not include the official name of the sender, and they were untraceable via a Whois database search. So essentially, you can access Whois and you insert the domain name, and it should give you the registrant's information. So it should identify who the sender is, perhaps their address, any identifying information you should be able to find there if it is registered properly, assuming they haven't proxy registered it or privately registered it. So there are various outcomes when you're looking at Whois. But back to Guthrie Ranker, here the court held that even if a sender used an unofficial name or an untraceable domain name, the claim failed because the sender's identity was easily ascertainable in the email of the body. And so that's very key here, is that the court considered whether the recipient could then look into the email of the body and figure out who the sender was. And so here the court reasoned that the plaintiffs could not plausibly allege that the sender attempted to conceal its identity because the entire purpose of the email was to market his website. So why would he?
Yeah, there's no need to, why would you obfuscate it if you're like trying to get people to go to your website and it's very clear what you're advertising?
Yeah, so they took that into consideration and they said, clearly, he's not trying to lie. He wants the traffic to his website. And so that was key in Guthrie Ranker. And similarly, in Silverstein, the same outcome in the sense that the court held, they dismissed the from name claims, saying that they were not misrepresented or they were not deceptive. But the allegations and the issues there that the plaintiff was alleging were a bit different. Here they had actual names of individuals. And so the plaintiff there claimed that the names were not familiar to him, that they were trying to spoof or some sort of identity theft. But the court held that he had no evidence of this. He didn't provide that the names were even familiar to him. So he didn't think that his mom was actually emailing him. And there was no proof of identity theft or spoofing. So they were technical issues and there was really no deception here. And then another significant case is Greenberg v. DMS. Here, the court also dismissed claims that the emails from names were generic. So the issue was that they were generic and they were from names such as like vehicle service plan. You couldn't identify who the sender was, like Shahin was mentioning earlier. It's something very, very generic. It gives you no indication of who's sending it. But the court reasoned that the phrases here, they don't make a representation as to the identity of the sender, so there cannot be a misrepresentation of the sender. So here the court highlighted the preemption concerns where the issue was immaterial. and it doesn't rise to that material falsification or deception that CAN spam does provide that savings clause for. So his allegations were preempted by CAN spam.
So the domain name requirements in California, we've talked a lot about domain names here, and the WHOIS database. We're getting a lot of demand letters and lawsuits about the whole WHOIS registration issue. And what we're seeing now is that plaintiffs will look at an email. They'll say, what is the domain name that's being used to send the email? And they'll go to something like domain tools or something else, and they'll put in that domain name and say, is it publicly registered? As Jasmine said, is the information about the registrant there? Is there a physical address there? Can I figure out everything there is to know about these people using this WHOIS tool? And so what we're seeing more and more of is that plaintiffs are saying, oh, it has to be absolutely publicly registered, such that if I go to domain tools or another type of open ICANN type search, I am able to figure out who registered it and what their information is. We disagree that that's a requirement for a ton of different reasons. There's case law that says that proxy and privately registered domains do not violate the law. There are issues in Europe now that say that you actually are the WHOIS tools and websites are actually not allowed to provide contact information about registrants because that violates privacy laws. So there's a lot of tension here. But when we're looking at it at its face and saying, okay, what can you not do? You're not permitted to use a third-party domain without their permission. You can't send something from somebody else's domain name without their permission. Similarly, you can't create a variation of somebody else's domain name. So instead of using bankofamerica.com, you're going to use 123bankofamerica456.com. The other thing that we're seeing a lot of, and Ari, I know you've got some more stories on this one, is this idea of providing inaccurate registration information when you're signing up a domain. So when you go to register your domain, you've got to give your name, contact information, and other stuff so that it's all issued in the ICANN registration information. What we're starting to see are lawsuits saying, okay, well, you've got a domain name, but the information you put on there was inaccurate. So when I go and search your domain name, I Google or I go to domain tools, and I find some address that's in the middle of the Atlantic Ocean, as opposed to an address that's legit, that I can actually find you and send you a letter complaining to you about your spam ad. So that's something that we're seeing a lot of. So being really, really careful when you're looking at the domains that you're registering from or the third parties that you're using, the domains that they're using to send it. We'll talk a little bit about third parties later, but being really careful about the domain registration. Again, as I said, plaintiffs are alleging that domains must be openly registered. I think that they're going to have a hard time winning that one, particularly in light of the GDPR and ICANN issues that are going on in Europe, and the fact that a lot of times we don't even have control. I register a domain. I have no control over what the WHOIS database is actually portraying due to privacy concerns.
I think it's a hard argument for them if especially in emails that otherwise identify who the advertiser is and gives the recipient an ability to contact that advertiser, especially for well-known brands.
Why is somebody going to
who cares what the registration is and what it's registered to, and like how many people actually know to go to the WHOIS database or even know what that is. So that's a legal theory that when we are given the opportunity, and we sometimes are given that opportunity, we plan to pursue very vigorously. I think it's just wrong to say that. And there's a case that I think Jasmine will take us through in a minute that's a little bit disconcerting on this point.
Absolutely. And then one of the other arguments that we're getting is this idea of routing, because we're talking about routing information, as Jasmine was saying about header information. Routing through third parties without their permission. We're seeing a lot of allegations regarding AWS, IMGR, and Google, and whether or not you actually have permission to route through that. Again, Ari, I think that's one of the things that we're going to be litigating and that we're going to fight against really, really hard, because this idea of whether or not you're allowed to route through these third parties is, I think it's pretty flimsy. If you've got something that's appropriately registered and you have a website, there's certain actions you take as a marketer to make sure that you're able to get from point A to point B. So the idea that you're not allowed to use these as routing situations along that road is flimsy. So we recommend generally just ensuring that you maintain your registration information, contracts with your registrant, documents of routing agreements, and any type of records regarding authorized services for SPF. So just keeping all that information. That's very unintuitive until you get one of these really technical lawsuits where the potential penalties are quite high. But let's talk a little bit about some of the cases let's start with domain name. How about that, Jasmine?
Yeah, so as I mentioned earlier with Greenberg v. DMS, this idea that a generic nonsensical domain name does not misrepresent the header information because it makes no representation as to the identity of the sender, that stems from this California Supreme Court case, Clefman. And here the California Supreme Court was answering a very specific question. It was whether sending unsolicited commercial email advertisements from multiple domain names for the purpose of bypassing spam filters constituted falsified, misrepresented, or forged header information under the California anti-spam law. And in this case, it was undisputed. The domain names used to send the email advertisements, they did in fact reflect the header information accurately. They were traceable and they existed. So they were technically, literally correct and fully traceable to the marketing agent. But they were generic, they were nonsensical, they were a variety of letters, numbers, they didn't make any type of statement. And so the California Supreme Court held that because no false statement was made and no misrepresentation was then made, that purely sending emails for the purpose of bypassing spam filters was perfect. It was fine. They dismissed the claims and it was completely fine. So as long as it's just bypassing a spam filter,
As opposed to trying to lie or just lie about who it's coming from.
Yeah, it's not materially misleading. Like if all you're doing is the email's otherwise compliant and you're just trying to get it inboxed, that's not going to be a violation. I mean, there's another case. I mean, if you send too many emails and you damage someone's computer, okay, that's a different issue, and that's going to raise a different cause of action. But the amount of email that you would need to send that bypasses spam filters in order for that to happen is like, it's a ton, and we don't really see that.
And that was the difference with Balsam, the next case, is that the court really emphasized and took into consideration the fact that they were actively trying to conceal their identity as opposed to just bypassing spam filters. And because of that, they deliberately obscured the header information, specifically the domain names, in order to become undetectable. And so that was the issue there, and that did violate the statute.
And it's important to go back on Balsam that there was an intent to, like the sender's salient motivation was not to bypass the spam filters, but rather to prevent identification. So I think that, a lot of people don't distinguish that case enough on that basis, but that to me is a big distinguishing factor. So now the more domain name cases, we've got Wagner versus Spire Vision. That was a good decision for the defense. That was granting summary judgment on the California claim for false and deceptive header information, where the email provided a link to the advertiser's website, a mailing address, an unsubscribe link, and like what the court held was that what matters is whether the sender's identity can be ascertained from the body of the email, and the recipient provided no evidence that the sender's identity could not be readily ascertained. So that is an older decision, but one that is helpful for defending these claims. One that is less helpful is the Greenberg versus Digital Media Solutions case. And that court held that an email with an untraceable domain name technically affirmatively and falsely represents that the sender has no connection to the actual sender, and that the domain names were not registered in such a way that would enable a recipient to trace it back to the sender. So it was an untraceable domain name case. And on that basis, and I think here's a key part of this decision that's a little bit helpful, the appellate court said that the case could go forward for determination about whether or not the emails violated the statute. What the plaintiff's bar is saying about this case is that it holds that if you have an unregistered domain name, or you have it, or some other domain name that isn't readily traceable to the sender, if it's proxy registered or whatever, then that means there is a violation of the statute. And that can't be what this decision says, because this decision just says the appellate decision says, look, the district or the lower court, sorry, it's a state court case, trial court dismissed the case too early, and that if you have an unregistered or an untraceable domain name, perhaps that combined with other factors might make the email unlawful. But this decision is often taken out of context, and the holding is taken out of context, and we think the context is important, but this is not a good decision. It's not helpful. It's not right. I mean, it's the law in the appellate jurisdiction where this decision was made, but I think it's just wrong. It's inconsistent with the preemption arguments, and it's focusing on things that don't matter to the recipients. Subject line requirements. This one is a little bit easier. So the subject lines have to relate, I mean, they have to be true, but they also have to relate to the bodies of the email. So there's more flexibility here, I think. So for example, like I'll give a very extreme example. If the subject line says, from your bank, enter your major bank name, your account statement is included here, open me now, and you open it, and it's an advertisement for a cruise or a nutritional supplement or some other subscription, that is not going to work under 17.529.5A3. There's just a complete mismatch. If there's some relationship, like it says, check out new homes now, and you open it up and it's an ad for real estate listings or real estate brokers or something that is some match, that probably will pass. The issue that we're seeing is, and again, we don't think this is the right way to follow the statute, is if there is a false advertising claim in the subject line that makes a subject line literally false, the plaintiff's bar is saying, well, that's a violation of A3, and we don't believe that's the case. That's not what the purpose of this statute is for. There's another statute in California for that, as there are in most other jurisdictions that deal with false advertising. And in California, anyway, there's something called Prop 64 that says that you have to suffer loss of money or property. You don't need actual injury to state a claim under 17.529.5. So that's another differentiating factor. But we are seeing the plaintiff side trying to stretch the limits on what can be a false and misleading subject line. It's still subject to preemption, by the way.
And that's absolutely right. And then some other state laws that we'll talk about later will address that issue too.
Do you want to talk about a couple of the cases?
Yeah, to your point though, Ari, that's a great point, is that in the Guthrie Records case that Jasmine was talking about earlier, you had subject lines that talked about a free gift. And the plaintiff said, well, it's not actually free. It's free once you enroll in an automatic renewal program. And therefore, your subject line is false. And what the court said is not quite, because you had free gift in the subject line. And then when you opened the email, it made very clear that the free gift was contingent upon making a purchase. And so the court said, you've got to look at the subject line under California law. You've got to look at the subject line in conjunction with the email itself. That's the whole point. That's what A3 says, is that you've got to set the subject line has to be false or misleading when looking at about the content or the subject matter of the email. And the court said, no, you have to look at together. And then when you read it together, it does say that you have to purchase something to get that free gift. Fact or myth? Private plaintiffs can recover under California law even if they don't open the email. That's a fact. Recipients can challenge the email even if they don't open it. So we've seen courts that say that the rule or the law 17529.5 provides a substantive right for consumers or recipients who suffer, quote, anytime the email is transmitted, not necessarily when it's opened, read, or relied upon. Let me give everybody the CLE code. That is MYTHS 2025, MYTHS 2025. In California, when you're looking at the penalties for somebody who's violated the law, the law provides for either actual damages, which is really difficult for somebody to prove what's your damages for opening up an email, some technical violations that may or may not be material, or up to $1,000 per email that's transmitted, with maximum liability per incident capped at $1 million. We have not yet really gotten into this, but the question is, what is an incident, right? So is an incident one campaign? Is it a bunch of emails sent with the exact same content, subject line, header information, and whatnot? Or is it something else? Is an incident very narrow such that plaintiffs can say, oh, there were 10 incidents and therefore I can get $10 million. So we're going to be seeing, I think, a little bit more of that as these cases are litigated more and more. Ari, fact or myth? California's email marketing law is the only one companies should worry about.
That's obviously a myth. Let's look at some other states. This is not exclusive. Sort of in the ranking of how frequently we see cases brought under the statutes. Washington has one. Maryland has one. Maryland's is based on Washington's. South Dakota has one. DC has one. Georgia has one, although it's not on here. Nevada has one. I think Nevada, parts of it, maybe all of it, are preempted. But we have seen a little bit of action there. So if you're concerned about what state you're in, if your state has one, but general rule, very, very general rule is if you comply with California, maybe then you generally comply with the rest. California, Washington, and Maryland are the big three. And then so
Jasmine, do you want to talk about Washington's?
So that is the other one. It clarified that. So this one's a little bit different than California, that assisting or initiating the transmission of a commercial email violates the Consumer Protection Act. That's what CPA is. So you have this interaction between the commercial email statute in Washington and the CPA. And so that part is a little bit different, but substantively, it makes it clear that unlike in California, where it's not as clear on the face of the statute, that assisting or initiating the transmission violates it. So you have that assisting piece in there. And then using a third, again, similar to Washington, or excuse me, California, using a third party's domain name without permission, misrepresenting or basically, lying about the origin of the transmission path, or false or misleading subject lines. The statutory damages are a little less. It's up to $500, or actual damages, whichever is greater. That's as to the recipient. Interactive computer service, ISPs, can get $1,000 of damages, whichever is greater. So it's another sort of like a spinoff of, or a variation, not a spinoff of California's law. Shahin and Jasmine, do you want to talk about heckle?
Yes. So where this differs from the California anti-spam statute is with the misleading subject line. So this case is particularly important because it defines the Washington law and states that it focuses purely on the subject line itself, as opposed to the entire contents of the email. So as we mentioned earlier in Guthrie Ranker, they looked at the subject line and they looked at the body of the email. And that is where they made their decision. Their reasoning came from the entirety of it. Whereas here, it's just the focus on the subject line. And so here, the spam was accompanied by misleading subject lines. It also was transmitted along misleading paths. And the spam messages also used the domain name of a third party who had not given permission. So there were a host of issues with the spam messages. But really here, the court emphasized that the subject line alone determines the deception. Even if the body clarifies its purpose, a misleading subject line still violates Washington's SEMA statute.
And that's a really, really big thing for companies to think about. Why? Because normally when you look at canned spam or California anti-spam law, they say that the subject line is only actionable. Somebody can only get monetary damages at $1,500 or $1,000 if the subject line doesn't relate to the body or the content of the email. However, if you look at Washington law, and there's a couple of other states as well, they say that if the subject line alone is false, misleading, unsubstantiated, whatever it might be, that immediately gives rise to statutory damages. And what does that mean? Normally, if there's a false advertising claim, somebody has to prove that it's false or unsubstantiated. They have to prove reliance, they have to prove it's material, they have to prove they depended on it, and things like that. Now, you've got these email marketing laws that say, no, I don't have to worry about any of that. All that matters is that you have a subject line that's false or misleading. It's false or misleading, boom, $1,000 in statutory damages or whatever that number might be in the relevant state. And we're starting to see cases on that issue in things like false sales, false or quote unquote false sales, false senses of urgency. In other words, you've got somebody saying, hey, hurry up, the sale's going to end soon. And then you open the email and say, oh, no, the sale's not going to end for 3 months. Or, hey, we've got this 30% off, but you open the email and it's actually not 30% off of anything. That's actually the normal price. So we're starting to see these cases come out and these demand letters come out where people are saying, look, we're going to use your subject line as a way to sort of circumvent other laws and requirements and burdens for us to prove false advertising claims. So this is another reason for companies to start really scrutinizing whatever subject lines that they're either using directly or that they've got their third parties using to send stuff out for them. So here's another case, Gordon versus Fertimundo. In that case, the Ninth Circuit held that certain claims were actually preempted because the statements were non-deceptive. They were immaterial, and they required, they essentially imposed a heightened content or labeling requirement. We spoke a bit earlier about this idea of, does the from line need to specifically say the official name of the sender? And canned spam does not require that. And what happened in that case was that the plaintiff argued that the from lines violated SEMA because they did not label or they don't identify the email's official sender name, and therefore that was a misrepresentation of the sender's name. And what the court said was, no, that's not true. You cannot impose a labeling requirement, because if you do impose a labeling requirement, that's going to be preempted by canned spam, because canned spam says that state laws can only survive if they prohibit material misrepresentation. And somebody not labeling something with a specific label is not necessarily material misrepresentation. And so the court said, no, you can't impose a labeling requirement like that, which I think is helpful for a lot of companies when they're looking at their from lines, like what can we use? You've got a little bit more flexibility that hopefully gives your advertising and marketing team a little bit of a breathing room on that one. So we've got some cases here about federal canned spam enforcement that you can read through, but I'd like to go directly, since our time's short, on ways to reduce risk. And Ari, I know you wanted to talk about some of these because these are questions that we get all of the time.
Yeah, so under the California statute, you can limit your liability if you can show that you implemented practices and procedures designed to prevent violations of the statute. Now, this has never actually been tested all the way through a trial because these cases generally don't get to trial. But if you have a policy that is designed to prevent against misleading emails and ensuring transparency, and that's documented, and most importantly, it's followed, the judge can, even if you let 1 or 2 emails slip through the cracks unintentionally, especially if you have a wide variety of use affiliate networks or third parties to send emails, you are going to be, the judge can cap damages at 100, and it's even better than that. It's like up to 100. So theoretically, the judge could say it's $10. So having a due care policy, and it just makes sense to have that anyway, especially if you're ever in any kind of investigation, you can say, look, before anybody complained about what we were doing, we had this policy, and maybe something went off the rails, maybe something didn't, but at least it shows intent to comply. So the next slide. So consent is also a way to reduce risks. We talked a lot, especially at the beginning, about how you don't have to have consent in order to send commercial emails. That's true. But if you want to reduce your risk under the California statute, get the consent anyway. Why? Because if you have consent, the statutory damages of $1,000 are off the table because the email has to be unsolicited and it has to be materially false and misleading. So if it's materially false and misleading, but you have direct consent, not from like a lead generator like that, but like from, I guess theoretically it could be from a lead generator, but ideally if you're a retailer, someone has given you direct consent, has told you yourself that you can email them, that takes $1,000 off the table. So that's why getting it is a good idea. I don't know what. And then if you use affiliate marketers, third parties to send emails, we've got to have solid agreements in addition to the due care policy, and monitor their activities. Some of the clients that have more sophisticated processes have affiliate marketing guidelines and email marketing guidelines. And those are good, also good things to have to prevent against risk rather than letting third parties do whatever they want, because ultimately the advertiser is going to be held liable for what the affiliates do. And California law is very clear on that. It's not a vicarious liability situation. It is strict liability, at least for now. And that's something else that I would love to challenge when given the opportunity, but that's the state of the law at this point. So we are right at the top of the hour. I see, sorry, we weren't able to get to anybody's questions really. I apologize for that because we had too much content, and we'll have the slides up, but do feel free to reach out to us after the presentation. We're happy to answer questions. We do this every day, all day, and we love what we do. Thank you all again for joining us, and we look forward to interacting with you soon. Oh, and if you want,
Thank you all.
and give us ideas for future webinars.
Yes, please do.
We want to cater to what you want, not what we think is helpful. So let us know. Thank you all.
Thanks, everyone.